We will call our first case of the afternoon, Petersen Financial versus Kentwood. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it all up, and ask that you do your best to keep track of your own time. And you have 2 minutes of a free fire zone if you wish.
Good afternoon, Your Honors. May it please the Court. Josephine DiLorenzo on behalf of Defendant City of Kentwood, and I will attempt to reserve 2 minutes for rebuttal. The city is asking this court to grant leave and reverse the Court of Appeals decision because the city had the power to adopt Resolution 5014 and modify the payment terms of the special assessment. The Court of Appeals incorrectly based its decision on the city's alleged failure to identify any express legal authority that affirmatively permitted its action. And then, even though the court recognized that none of the circumstances for adjusting a special assessment that are addressed in the city's ordinance actually applied to the situation, the court still faulted the city for failing to comply with the ordinance. But when it ruled on this case, the Court of Appeals did not have the benefit of this court's decision in Sheffield, which is controlling. Here, the relevant laws are silent, and there's nothing in the city's ordinances or the General Property Tax Act or any other state law that prohibited the city from adopting a resolution to modify the payment terms of the special assessment. So therefore, under Sheffield, the city's act is permissible. The holding in Sheffield is based on the relevant constitutional provisions and prior decisions from this court, in particular, City of Detroit versus Walker. So I know you know what Article 7, Section 22 says, but I would note that it says a city has the power to adopt resolutions, which is the issue here, relating to its municipal concerns, property, and government, subject to the Constitution and law, even when the city lacks an expressly enumerated power. And then there's also Section 34 that says constitutional provisions and laws concerning cities shall be liberally construed in their favor. The Home Rule City Act uses language similar to Article 7, Section 22, when it specifies what may be in a city's charter. And so...
Counsel, good morning. My thing is I like to try to keep things simple.
Right.
And that's just my thing.
Right.
And
I mean, if I could do it in 30 seconds, maybe.
No.
Sit down.
No, but the thing about this case is it kind of goes to that theory that I've always kind of adopted, which is it seemed like the resolution was clear. It seemed like it was ambiguous. It seemed like it was pretty well defined. So why is it that in this situation a person can't rely on a resolution that your client ultimately passed that was quite clear and there wasn't any ambiguity to it?
Are you talking about the resolution,
Yes.
the one that the Court of Appeals
Yes.
said was no good?
Yes.
I don't know. I mean, I think it comes down to my 30-second explanation is that, you know, the city has the power to specially assess. The city has the power to enter a contract. They pass this resolution. Obviously, they can adopt resolutions.
But if I'm a person who wants to invest or rely upon, you know, what I mean, if I do my due diligence, it seems pretty clear that this was, you know, a resolution said what the resolution said. That the concern I have, and if you can help me with that, is that if I'm a person who's investing within that community, am I not able to rely on a resolution that was ultimately passed by the city?
Yes. Well, the first resolution.
But you can just change it. I mean, it's hard for people to know what they can invest and what they can do if you're relying on something and then it change. I mean, there has to be some. You know, the notion of basically if you're buying it based off of this perspective understanding, and then all of a sudden it changes, it's kind of like you're changing the rules of the game.
Well, it was still owned by the original property owner when this Resolution 5014 was adopted, and that was the person that had waived notice, had waived procedural irregularities, but they were still given notice, and there were no objections. And it was just extending the payment terms, which I think the amicus brief made the point that actually was going to also help the property owner. So no one was being deprived of any right here by this, by the change. So, and again, I mean, I can't stress enough that they had waived anything, you know, any procedural irregularities, but they still had notice and didn't object. So, and I don't know why they would, because it was supposed to be helping them. And the property wasn't sold until after that. So,
Okay,
does
no,
that
you've done
answer-
fine. No, you've done fine. Please
Okay.
continue.
All right. So I was just going to make the point that the city charter, because it tracks the Home Rule City Act, it allows the city to exercise all municipal powers permitted in the management and control of municipal property or government, whether such powers are expressly identified or not. And the city may perform any lawful act to advance the interests of the city. So again, this is fiscal responsibility. And again, it's helping the property owner, but it's also helping the city to the tune of $400,000. So I think we can just go back to the beginning and break down what happened here. I don't think there's any dispute that a municipality has the power to specially assess property. That's in the Home Rule City Act, it's in the city's charter, it's in its relevant ordinance. And then in this case, of course, the special assessment came about through the voluntary special assessment development agreement. And the parties agreed that a special assessment would be created by resolution consistent with the city's ordinance. However, it is important to the issue that you are just considering today is that in that agreement, the developer also expressly waived any objection to notice, which I discussed earlier, and procedural defects. And it's also important that in that agreement, the city reserved to itself the discretion to set the payment terms of the special assessment by resolution. And then there are two additional relevant points. Okay, aside from the fact that the city charter gives the commission the power to contract on behalf of the city, almost 100 years ago, this court held in Groseal Township versus New York Indemnity Company that an agreement by a property owner wishing to have his property benefited by local improvements to pay the assessment therefore violated no principle of public policy and is enforceable. So the way this special assessment came about through this agreement, that's permissible, at least it has been for quite some time. And then the second point is that in addition to the development agreement, the city also adopted a series of resolutions, and it culminated with Resolution 9604. And even the Court of Appeals recognized that the Court of Appeals, that resolution created a valid special assessment. And then it's also important that that resolution incorporated the terms of the development agreement, which again, it gave the city the discretion to set the payment terms. So what the Court of Appeals decision comes down to is that the Resolution 5014, which extended the payment terms of special assessment, was invalid because in the court's view, the city failed to comply with its ordinance. But under Sheffield and the Constitution and the city's charter, where the ordinance is silent on amending payment terms, and where there's no other law prohibiting the action, the city does have the power to amend the resolution, amend the payment terms. And that should be the end of the analysis. But even if you continue and if you want to look at the city's ordinance specifically, I would still argue that the city had the power to extend the payment terms by resolution. This is all laid out in the brief, but Section 5011 of the ordinance concerns due dates specifically, and it acknowledges that the city commission may make special assessments payable in future installments. And then if you move on to Section 5012, it goes on to state that the city commission by resolution may provide for the payment of special assessments in annual installments, and it can go up to 20 years. So if you broadly construe that, that means the city commission has the power to set payment terms, and since the initial payment term here was 10 years, the city could later extend that term an additional 10 years. But instead of looking at the provisions specific to due dates and future installments, the Court of Appeals and the plaintiff focus on Section 5010, which addresses changes and corrections to the special assessment role. The language of that provision discusses changes or corrections made in response to objections, but here there were, again, no objection from the property owner. The provision also states that the city may correct the role as to any special assessment or description of any lot or parcel or land or other errors, or it may annul the role. So here, no one's saying that there are any errors as to the amount of the special assessment or as to the description of the property, or no one's really saying there's an error. And then the Court of Appeals actually acknowledged that Resolution 5014 did not alter the amount of the assessment, and it didn't reconfirm the role. And this is important because plaintiff and the Court of Appeals focus on the language that says the role shall be final and conclusive. So we made the point in our brief that the special assessment role and the due date of the installments are distinct concepts. The role describes the land, the owner, and the associated benefit valuations. So again, there's been no change with that. So what the final and conclusive language as to the role, that's really for purposes of appealing to the tax tribunal. So it's more of an issue of procedure than substance. And like I've said this 5 times, but again, there was no objection from the property owner here. I think I can end with that, but just to say that the bottom line in this case is that the city spent its funds constructing infrastructure with the expectation that those funds would be repaid by the owner of the benefited property. So it was in the interest of fiscal responsibility, which again, they can act in that interest under their charter, that the city sought to amend the payment terms of the special assessment, and it was prior to any foreclosure proceedings. And because it was prior to that, it didn't violate the General Property Tax Act. And so their act in adopting Resolution 5014 was not expressly prohibited by any state law. Is there any questions I can answer now?
Counsel, I actually was just wondering, it was raised in opposing counsel's brief that Kentwood could have just turned the assessment deficit over to the county treasurer for reimbursement. Was that an option?
That issue didn't come up before, so I can't make up an answer for that, but okay. I do know that I guess ultimately someone would still be responsible for that $400,000. So, I mean, are we still going to let someone have a free ride because of that? So that's what I would say on that.
Thank you.
Any other questions? Okay, thank you so much.
If it please the court, Donald Visser on behalf of Petersen, which is the putative appellee and the respondent in this case. One of the things I'd like to make clear is what the difference is between a resolution and the assessment role. And I found previously that sometimes there's a lack of understanding there or appreciation of what that is, and I think the appellants in this particular case actually prey on that misunderstanding a little bit. The assessment role is attached to the resolution. The assessment role does not just include the property owners, the property description, and the amount. The assessment, part of the assessment role is the term. The term is not part of the resolution, it's part of the confirmed role. And I ask you to look, if you want to see that, how that's illustrated, it's in the appellant's appendix at pages 404A, that's the resolution, and 407A through 412A is the actual assessment role. So now that comes into play when we start talking about what the Court of Appeals did, looking for some express language in what's being challenged here. It's not necessarily the absence of express rights to go ahead and do what they did, but rather that there is express prohibitions contained not in state law, in the state constitution, but in the city ordinances itself. That's where the biggest problem that the city has in this particular case is you drive down all the way. So we don't involve issues like Sheffield or any of the other cases that are really involved here. What we're talking about is local ordinance. And we'd all agree, I think, that we have a fairly expansive reading of what rights a city has. Sheffield is very clear at that, although there's a multitude of opinions in Sheffield. I think the ultimate conclusion there is pretty broad powers.
Counsel, I wanted to just chat a little more about the notion of what is an assessment role. I have to admit, I think of like, oh, what is the tax roll for where I live? I think of it as just a list of properties. It's the designated properties. So how is it more than that?
Because within the assessment roll, and you'll see that on page 407A of the appendix, the properties described, the owners described. In this particular case, it's a large single-piece property. the amount of the assessment, remember, and I'll talk about that a little bit more when we talk about what's in the charter and what's in the ordinance, and the term. So the term is not part of the resolution. The term, the 10-year term, is part of the roll. So when the roll is approved, then that included in there is the 10 years. So that's what's so important to the argument that we've made about final and conclusive. It's not that, well, it's part of the resolution, it is part of the confirmed roll here, that 10 years. So now within what's being confirmed as final and conclusive is 10 years. Final and conclusive doesn't mean it's subject to willy-nilly changes down the road, because you have otherwise the power to do so generally. You've locked yourself in. And we all, I think, can agree that although the 1963 Constitution gives through Section 22 and more so through Section 34 of Article 7 gives great latitude, it still flows, their power flows through a legislative grant. The legislature enacts the ability to incorporate as a city. The next step, and that's where you were with Sheffield, how do you change the charter? Charter is the core by which a city operates. One of the provisions, a permissive provision under the Constitution for a city charter is the ability to make special assessments. Kentwood provides for a permissive special assessment. What does it say? It says there, you will be provided, this is Kentwood's charter, mandatory, a complete procedure for all assessments. Not partial procedure, a complete procedure. So now, their charter provides what has to happen. What did they do? Kentwood passed a charter. Passed an ordinance for special assessments. So now we're getting there to the authority to have the charter. They say, in two sections, if it's a single parcel, one section said it must be complete, it is conclusive and final. Another section, which is multiple parcels, complete, and is conclusive and final. What the problem here is the city doesn't want to obey its own ordinances. Now you're getting into some questions about what does the city charter mean? Does the city have to follow its own charter? That's not what Sheffield was all about. We've got the broad spectrum there. But what you're really looking at now is, can a city, that's the question that's being presented, can the city go ahead and do whatever it wants to because Section 34 of Article 7 gives its broad powers, and it doesn't have to obey its own ordinances?
Council, how should they have handled it? What should they have done differently, in your opinion, if they were going to try to preserve their rights?
The simple answer, and why I say this is not a reoccurring problem and why you shouldn't take the case, is they said it was delinquent. They acknowledged it was delinquent. They should have just returned it under the GPTA to the county treasurer. They would have paid the full amount.
Okay, well, what about the point that opposing counsel made, that obviously then the taxpayers are on the hook? It's a pretty big windfall to your client. I think it was quite a large windfall, correct?
Well, the county the revolving fund is potentially on the hook. Now, up until Raffaele, that revolving fund in many counties was astronomical due to surpluses that were coming in. And I think that's maybe fit into why Kentwood didn't want to do it, because there's some accounting that goes on between.
But is that the only solution they had? Let's face it, developers go belly up. Cities have, entered into these agreements with developers and obviously want to try to preserve the taxpayers' rights. So is there another way they could have preserved their rights on this?
I think under the particular facts of this circumstances, no, there is not, because you run into the 211-78K5 by C and E, which this legislature has said it's extinguished. So those are extinguished type of thing. That's a policy decision that the legislature has decided that when you get to that particular point. So you turn it over and it fits into the minimum bid. And that's the minimum bid at the first auction. If it doesn't sell, then they can go and put a lower minimum bid and sell at the second auction and recoup some of the funds if it doesn't sell for the minimum bid. But that's a legislative call, not one to fix, that this court should try to fix or use this as a vehicle to try to remedy. Again, it was just, in our opinion, as I look at it, just I don't know, no one's told me why, but it looks like a dumb call to not have turned this over and to have gone through this charade. There was another property, part of this, that went through, the owner's name was Dan Gami. It's a case that also went to the Court of Appeals, and this court denied cert on the application for that. But that was sold the prior year. So it doesn't make sense to me that they're fighting a great policy debate here or trying to get you to pick it up when in fact the real issue here is very, very local. Just to look, the issue here is whether the ordinance allows them to do what they did. And they say, well, we can do it by resolution. But if you look at what a confirmed roll is, a confirmed roll is 10 years. It's not 10 years subject to modification. And I just don't think that since the charter mandates that it provide a complete procedure, that if there's no authority within that complete procedure, they don't have the authority to do what they did in this particular instance.
Counsel, I have a question. You I think rightly have focused us on the ordinance, and this in some ways doesn't involve broader questions, but one broader question that in fairness I don't think your opponent has really raised or relied upon is whether in the development agreement the city could bind future city commissioners from exercising the power to change the term of years. You know, we see this same question arise whether one legislature can bind future legislatures, and here we have a provision that seems to bind future city commissions from doing something that they otherwise would be able to do. I have that concern as sort of a broader concern arising out of this case. Again, I mean, you can correct me if I'm wrong. I don't know that the issue is necessarily in the case, but should we be concerned about that?
I don't know what you should and shouldn't be concerned about it. For me, I don't see it as a concern, but again, I have some blinders on, which are blinded a bit by the facts of this case. I don't see it an issue because I see it being terminated, that agreement being terminated under 211-78K5. So as far as applying to the facts of this case, it's extinguished. I mean, that's a legislative act of extinguishment. In the broader perspective, I would question, be very honest with you, the propriety of whether one can contract or not, but again, I'm talking off the top of my head without being sufficiently researched into that. It just, in my mind, it would raise some public policy questions, at least for me. I think this case raises some public policy questions as to whether Kentwood can go ahead and do something that the GPTA says is extinguished. And, no, it's not extinguished. We're just going to we're just going to keep it going. And of course, that I think created some confusion in this case. At least in the prior, we had one prior published case on this in the Court of Appeals, Petersen 1, because we took a dual approach to it, a contract and ordinance. What is it? Because one subsection of 78K5 talks about contracts and the other subsection talks about special assessments.
Counsel, looking at it from a practical perspective, just from sister counsel, what about the infrastructure? What about the cost the city put into this and, you know, ultimately in that perspective?
as far as recouping it?
Yeah, I mean, she basically, your sister council basically brought up the infrastructure, brought up the fact that the city did put some work into this and, was reliant upon, the monies that the city claims to be owed. How do you comment to that?
Well, again, Your Honor, I think it's a conflict with the public policy announced by the General Property Tax Act when it, as part of the foreclosure process, extinguishes these obligations. That's really a policy question. Should that be extinguished
Right.
or not? And as you can see, the question there gets even finer because it's real clear that the property, when it comes to special assessment, it extinguishes all past obligations and not future obligations. So the legislature made a policy decision to cut the line there. In this particular case, for the local government, there's no risk because all of that money, if they just turned it over in return and it was delinquent, by the time it went to foreclosure in April of 2015, everything had been delinquent. All the resolution basically did was a forbearance agreement. It didn't change. The resolution itself says without reconfirming. Well, if you didn't have a confirmation, you didn't change the original confirmation. You're still stuck with 10 years. So now you have just simply an agreement to forbearance. I am concerned that the overall perspective here, though, is one of broader grasp. That's, I have a case right now in the Court of Appeals in which local unit of government has enacted an ordinance that says, if you sue us, you have to pay our attorney fees. And basically, they expect the court at that point to fit that within the statutory exception for the administration of justice within the court system and say, we have the same powers as the legislature does to go ahead and impose on the courts, which are administered under different rules and under the Supreme Court's direction, your direction, say we could, because we put it in an ordinance, that's the same thing as putting it in a statute. I think there's a broader grab that's trying to come into play here. I don't think after Sheffield, this case warrants your consideration for granting leave. So I thank you very much.
Thank you.
Thank you, Your Honors. I just wanted to address Justice Viviano's point. I don't think that the language of the development agreement intended to bind future city commissions because it says, it lists the things that the commission has discretion on, including the term of years, and it says without limiting the foregoing. So it's not intending to limit that. It just says the party's intent is that the special assessments will be consistent with the following guidelines. So I don't think I think that leaves room for changes because it said it didn't limit the discretion. And then, so to council's point about the role, I would reiterate what I said before on what the definition of a role is. But if you look at the actual document that says, well, first I would say that Resolution 9604, again, incorporates the development agreement. And then if you look at this document that's labeled the role, it has, the subject property and the valuations, and it does have the term of years, but it also refers back to the development agreement. And so that would also refer back to the discretion of that first 10-year period. So that's what I would say to that. And then I would just reiterate as far as the General Property Tax Act, again, no private rights were being denied here. And I would suggest that there's a balancing of interest in that provision about extinguishment because the legislature intended that that future installments would survive foreclosure. So on the one hand, yes, the legislature does intend that the taxing unit will absorb the cost of any past due special assessments, but it's also clear that the legislature doesn't intend for anyone to get a free ride or a windfall, which is what plaintiff wants in this case. Again, because it specifically exempted the future installments. So We did quote this opinion from this court, Voight versus City of Detroit, from over 100 years ago, and it says, where taxation for any local object benefits only a portion of a city or town, that portion only should bear the burden. General taxation for such local objects is manifestly unjust. So that's what the city's object was here, and again, it wasn't trying to deprive anyone of their rights. So that's all I would say, unless you have any questions.
Don't see any. Thank you.
Okay,
Case will
thank
be
you.
submitted.